Be ready for the dictation. 5 seconds to go. The order was affirmed by a single judge of the High Court. The division bench of the High Court, however, set aside the order of the single judge and quashed the order of compulsory retirement on the ground that the complainant was not examined. The appellate authority, while setting aside the order of removal and directing for de novo inquiry, earlier had found the same had in law on account of various grounds, including the ground of non-examination of the complainant. Thereafter, in the de novo inquiry, the inquiry officer had taken pains to call the complainant from his native place, but he did not appear during the inquiry. It is not the case of the respondent that the disciplinary authority purposely withheld the complainant from appearing in the departmental inquiry from the order of the disciplinary authority does not act as a court of appeal and appraise evidence. It interferes with the finding of inquiry officer only when the finding is found to be perverse. The division bench of the High Court erred in setting aside the order of single judge and quashing the order of compulsory retirement. The finding recorded by the inquiry officer was based on the materials on record and on proper appreciation of evidence, which cannot be said to be perverse, calling for interference by the High Court in exercise of its power of judicial review. A copy of the written complaint was produced during the course of inquiry, which supports the charge leveled against the respondent. Further, the respondent in his defense had accepted the detention of the complainant and his release. However, he denied the allegation of snatching of money from him, but from his own defense, it is evident that he had accepted the incident, except that he had not snatched the money. On the basis of the materials on record, the inquiry officer held the respondent guilty, with which the disciplinary authority as also the appellate authority agreed. It is well settled that High Court, while exercising the power of judicial review, the inquiry officer held him guilty of the charge, and the disciplinary authority agreeing with the same inflicted the punishment of removal from service. The writ petitioner preferred appeal, and the appellate authority allowed the appeal, set aside the order of removal, and directed for de novo inquiry, and while doing so observed as follows: However, I find that there were some gross irregularities in the course of the proceeding inquiry. First, from the very beginning of the proceeding, the delinquent should have been given the option to engage a friend for defending his case, and thereafter, in presence of his friend, the inquiry should be started. Secondly, the complainant was not examined during the course of proceeding inquiry. Thirdly, the complainant's story of delivering of a tractor at Burdwan and boarding a train from Asansol after that required further examination by EO and cross-examination by the delinquent. Thereafter, a de novo inquiry was held in which the writ petitioner was allowed to engage a friend.